Now, you may have heard, matter of fact, scratch that. I'm certain you have heard that a lawyer has gone to court to demand that former President Goodluck Jonathan does not get anywhere near a ballot come 2027. Well, a new suit before the Federal High Court in Abuja seeks to stop former President Goodluck Jonathan from contesting the 2027 presidential election. The plaintiff, John Mary Jideobi, is asking the court to bar Jonathan from presenting himself to any political party for nomination and to restrain INEC from accepting or publishing his name as a candidate. He also wants the Attorney General of the Federation compelled to ensure compliance with the court's decision. In an affidavit filed in support of the suit, deposed by one Emmanuel Agida, the plaintiff described himself as an advocate of constitutionalism and the rule of law. He argued that if Jonathan were to contest and win the 2027 presidential election, which has a 4-year term running from 2027 to 2031, he would exceed the constitutionally allowed maximum of 8 years in office as president. And of course, this rekindles a debate over the former president's eligibility. So, is Jonathan eligible to run? Yes or no? That will determine whether the young man is trying to waste the court's time or he's onto something. Well, my guest, as you can imagine, is a legal practitioner. He's a professor of law with the River State University, Professor Ritchard Wokocha. Thank you, Professor Wokocha, for making the time. How are you doing, sir?
I'm good. And good evening, Nigerians.
Good evening. So, I want to start by asking the question this way. Does the Constitution create a distinction between 2 terms and 8 years? Because it seems to be the number of years that's causing the problem here.
Well, the Constitution talks of 2 terms in the sense that it says a person who has, following having been declared winner or having won the elections, won the position, shall not be so sworn in beyond 2 times. So it's clearly referring to terms. But the gentleman's suit specifically mentions Section 137, subsection 3.
Okay.
Which says, I'm reading now, the person who was sworn in as president to complete the term for which another person was elected as president shall not be elected.
Okay.
He is specifically referring to this to hold that by virtue of this section and the fact that the Constitution is supreme and no part of the country shall be led other than is prescribed in the Constitution as provided in sections 1, subsection 1 and 2 of the Constitution, that the court should hold that Jonathan is not eligible.
Okay.
So that's his ground, or that's his case before the court.
So, holding on to that, that means he has a case.
He thinks there is a case and is asking the court to confirm that that is the situation. That is the provision of the Constitution, quite all right. But the critical issue here is that that amendment came in 2018. And that was long after Jonathan's time in office.
Yeah, okay, so Jonathan has been sworn in twice, but he won an election once, right?
He won an election once. He was sworn in as president once after winning an election. The other one was the statutory completion of the tenure of Yaradua, who was elected as president.
Yeah.
At the time. So, the primary question one would have asked is, what does young man mean? He has stood for election again and failed. So if he wasn't qualified, why did he have to stand for the election for that second time that he lost? What has happened between then and now? The only thing that has happened is amendment of the Constitution. But that constitutional amendment cannot take retroactive effect. So it takes effect from that time. It cannot apply to the period before it was made.
Okay, Prof.
So
Now,
that is what the court has to determine whether that provision made in 2018, that amendment, subsection 3 added in 2018, reaches back in time to cover people who had occupied office before that time. That's basically the case is bringing.
okay, so let's assume, which I would imagine is the case, it will not affect Jonathan, whose miracle of two-term presidency with one election victory was before that amendment. But if he's going to run, it's going to be in the future, not in the past. So in some way, it also covers it because the new election is under the amendment.
The new election is under the amendment, yes, but the question is Jonathan a person who falls into that category? Because our rule took effect from 2018 when it was made. So
Okay.
the court will have to determine that, whether that constitutional provision takes retroactive effect to cover periods before that time. In any case, that's just for clarification of the case. That question has already been determined in 2022 when somebody went to the Federal High Court in Bayelsa State at the time to stick the same prayers. And the Federal High Court ruled against him, saying that Jonathan was qualified to contest the election. That was 2022. So there has been no overturning of that decision. There was no appeal against it. So this is almost like abuse of court process, because he's seeking to do what has already been done and what the Federal High Court has already given a ruling on. So we are going to Federal High Court Abuja to seek the same thing that has been determined by Federal High Court.
Okay. And I'm glad you brought this up. So my next question, what is the protocol for precedents? Since there has already been a ruling on this case, do lawyers not have access to those rulings? And Nigerians in general, if I want to take a certain case or a person to court and it's being deliberated upon, what's the protocol for me to know that this is an issue I should not pursue because deliberations have already been completed on it?
That party, the person bringing the case, is a lawyer. So he ought to have known. Presumably, the ordinary position is you bring whatever, everybody is allowed to go to court and take any matter to court. And the court will hear parties and rule. So let's say, if we presume that he is not aware of that, is the defendant lawyer or of the defendant to bring to the attention of the court that this is an abuse of court process because this matter has already been determined in a previous case by a sister court, and the court cannot be asked to sit on appeal over the decision of a sister case, over the decision of a sister judge, Federal High Court judge. So it will be the responsibility of the defense lawyer or the defense department to matter the invested Federal High Court decision from Bayelsa.
Okay. Now, Prof, let's look away from the Constitution a bit and just apply logic. In Jonathan's case, Yaradua died 2 years later. So Goodluck did 2 years of Yaradua's administration and then 4 years of his, which qualifies as 6 years. Let's imagine we have a situation where maybe a principal, in this case a president, dies maybe 3 months into his tenure. And then his deputy completes his tenure, which is almost the entire 4 years.
Yes.
Will this deputy be eligible to run again, considering that, give or take, he completed 2 terms? And of course, this deputy was able to go and contest and won his own election. Will the same rules apply, considering the difference in time?
If it is happening now, this rule in the Constitution, section 137, sub 7, will disqualify the person if it is happening now. But if it is something that happened before this Constitution was amended to that position, then it will be a different situation. Assuming Yaradua died 2 weeks into his administration, and Jonathan completed the term statutorily, not having been elected as president, he will be entitled to contest 2 times, which he has already done once and won. The one that he didn't win, he can contest again and win if he's able to win. It will not be bad because the law did not exist before the activity we were talking about. Law does not take active effect.
Mm-hmm. But don't you think, and this would be a rare occurrence, this would affect in the future, let's say maybe a president now dies 2 weeks to the end of his tenure. The deputy might not want to be president because he knows it will disqualify his 2 terms. Will this also not affect?
A vice president would then be able to say, I resign, I don't want to complete the term. If he is sure that he can win the election from outside, so he can resign. If he resigns, then he resigns as a vice president, and he will not be affected by this rule.
Okay.
Because the rule is specifically targeted at those who have completed the term of other people, saying that they should not contest more than once thereafter. So even if it's midway or 1 week into the presidency or 1 day to the end of the presidency, and the person completes the term, he's affected. But if he opts out and resigns, and he resigned as vice president, he has not been sworn in before or elected as president before. So if he wins, he will be entitled to run again a second time.
Okay, finally, Prof, before I let you go, and this is on a political, not a legal note. I'd like to get your personal opinion. What's your take on what I will call the seeming leadership recycling? The idea that Goodluck Jonathan, a former president, is even considered to rescue Nigeria at this time?
Politics is about, it's supposed to be, or it is, because even if we are doing something different here, it doesn't change what the reality is. Politics is about popular choice and the people making a choice. I think what you're observing is the fact that parties are looking at candidates that have national appeal.
Yeah.
Candidates that already have clout to be able to make impact or win support across the line. So I think that is what is creating that. You may say it's virtually the same thing that has happened in America in the last 3 terms.
Yeah, with Trump.
The American presidency. But I think that is what it is. If a party finds a candidate who can sell easily, they want to use such candidates.
Okay.
So if they are recycling, it's because they are looking for a candidate who has sufficient appeal, national appeal to be able to. And a candidate like Jonathan has been president, so the voter will have the opportunity of comparing his presidency with the incumbent whom his party wants to get out of the line and taking a decision. So falling back to such person who has ruled before, it's like comparing scorecards, and you do that only when you are sure that his own scorecard is far superior to that of the incumbent whom you are trying to unseat.
Okay. Well, thank you very much, Professor Wokocha, for your time. It's always wonderful doing this with you. We appreciate it, sir.
You're welcome, Sam.
Have a beautiful day.
Welcome.
We'll take a break. After the break, you and I get to talk. Should former presidents be allowed to run again if they completed someone else's term? The Constitution has already answered that. The next is if you think this suit is politically motivated or it's a genuine concern. Again, perspectives have been shared, but I'd like to hear yours. Stay with us.